Welcome to the roundtable debate at the 8th PATCON. We have Publius Huldah, we have John Ainsworth, we have KrisAnne Hall. I'll be moderating today. Rules are simple. The audience has submitted questions in advance. Normal rules of decorum, don't talk over anybody else. And pretty much that's about it. We're going to go in order. So that means Publius Huldah will get the first question. First question to Publius Huldah.
Huldah.
Second Kings.
Yeah.
In your talk, you listed many unconstitutional acts not on the list, even permitted to sneak their way onto the list. And I already had a question in here too that follows up on this. The reason that the delegates or our representatives do this is they use the General Welfare Clause. Even when I printed out or pointed out to them that based on the Federalist Papers, that's not what the original intent is. So I'll let you take that question.
Sure. In Federalist Paper number 41, in the last 4 paragraphs, James Madison, father of our Constitution, explained the meaning of the so-called General Welfare Clause. The General Welfare Clause is found in Article 1, Section 8, Clause 1. Let's see. Yes. Congress shall have the power to lay and collect taxes, duties, imposts, etc., to pay the debts and provide for the common defense and general welfare of the United States. Madison points out, Federalist Paper number 41, last 4 paragraphs, that is in the introduction to Article 1, Section 8. Immediately thereafter follows a list of the specific purposes, the specific powers which limit and define the general expressions of power set forth in the introductory clause. So, Congress can only raise taxes when it is to carry out one of the enumerated powers. It only serves the general welfare when it is carrying out the delegated powers, the delegated enumerated powers. Our framers had a very different understanding of the term welfare than we do today. Today we think it means handouts, a social safety net, food stamps, and the like. But our framers understood it to mean the general welfare, that general state of peace and prosperity which a people have when they have a civil government of only delegated and enumerated powers. I have a paper which explains the original intent of these 3 abused clauses: general welfare, interstate commerce, and the necessary and proper clauses. My paper is online. Contact me and I'll give you the link where you can get this paper. It's 1 page. Actually, it's a handout sheet. I just didn't bring it with me. But it proves the original intent using the Federalist Papers of those 3 clauses.
I would also like to add to that James Madison in 1792 made an argument before the House of Representatives on this very matter, where he articulated again his explanation as to what the General Welfare Clause really means. And if you want to find that, that is James Madison on the Cod Fishery Bill of 1792. And it's a very excellent explanation. And I have an article in the General Welfare Clause as well. If you want to go to my website, it'll give you a link to that text of the Cod Fishery Bill.
John?
Well, my take on it, obviously, is the general welfare was changed when everything was nationalized to Publius's position that it was just an introduction to the rest of the enumerated powers. If you go to Article 1, Section 8, Clause 17, one of the powers that Congress has granted is to exercise exclusive legislation in all cases whatsoever over such district and their citizens. It gives them the power to pass exclusive legislation in all cases whatsoever over citizens of the federal government, the nationalized citizenship.
No, no.
There you go.
He's referring to Article
Here.
1, Section 8, the next to the last clause. That is the clause which deals with the federal enclaves. The District of Columbia, which will be the seat of the government, of the federal government, which shall not exceed 10 miles square, military bases, post office, dockyards, and the like. Yes, Congress has exclusive legislative authority over those limited geographical areas. Those are the federal enclaves. The grant of exclusive legislative authority is limited to these tiny geographical areas.
I would like to mention that when you come across these things just as a tool, because remember, I'm not here to teach you, I'm here to recruit you and train you. So when you come across these clauses and things that you have question about, one of the things that will help you discern the truth is understanding why they were put there. And the General Welfare Clause is an addition to our current Constitution from the Articles of Confederation. It's a direct response to one of the flaws in the Articles of Confederation. One of the flaws within the Articles of Confederation was that the federal government was engaging in inequitable treaties. They were creating treaties, I think as Ms. Publius talked about, where they were benefiting one state and detrimenting the other. So one state was getting all the benefit and the other state was footing all the bill. And we were literally on the verge of foreign war with other countries because we were breaking these treaties, which are just contracts with foreign governments. And we were on the verge of a war between the states because they were bickering over these inequitable treaties. Like the state who got all the benefit was ticked off at the state who wasn't paying the bill. And so we were at risk of civil war and foreign war over this really one important issue. So the General Welfare Clause, and Madison explains this as well, that was placed into this more perfect Union Constitution to as a description of the power to be used so that when the federal government ever engaged in any of its enumerated powers, it was reminded that it must have the general welfare of the entire Union in mind in exercising these powers. It cannot benefit one state over another and hurt one state over another.
Yeah,
Let me get my point in here. Both of those are under the premise that nothing changed with Reconstruction. They both are talking about original intent. You know, my perspective is never dealing with original intent because I say the foundations are overthrown. I think if you go to some of the first rulings on the 14th Amendment, U.S. citizenship status, you're going to go to Elk versus Wilkins, 1884 case. Elk versus Wilkins says, it's talking about says the persons declared to be citizens in the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof. The evident meaning of these last words is not merely subject in some respect or degree to the United States, but completely subject. Okay? So you have a situation where this new national citizenship, the citizens become completely subject to the jurisdiction of the United States. One of the things that, the points of contention I think we have here is what is the definition of a state? A state originally was composed of the people that had the common law freeman status. And I've got a little thing here of the original state of North Carolina. If you look to the preamble of the Constitution of North Carolina, you find out who the body politic is, who the state is. The North Carolina Constitution of December 18th, 1776 says this. I'm going to compare it to the Constitution of 1868, the Reconstructed Constitution. It says, wherefore, it becomes necessary that government should be established in this state. Therefore, we, the representatives of the freemen of North Carolina, chosen and assembled, and then you go to find out who can vote, and it's going to be the freemen, aged 21 years, who have whatever property ownership or whatever. The Constitution of 1868, which was forced upon us, people who can vote, who the body politic is, every person born in the United States. Is that the same state? Think of it this way. If you've got the European Union, and the European Union is fairly similar to the American Union as it was originally founded, where every state is sovereign. France is sovereign, Germany's sovereign, Great Britain's sovereign. They've lost some aspects of sovereignty just by joining a union. Well, would it be different if the people of France are the sovereign body of France? Is there a difference if you change that to anyone born in Europe residing in France has political power? Has the body politic, has the state of France, its character changed? And the answer is yes. And in this country, and going to Publius's concept on creator and created, she's absolutely right. The state's composed of freemen created the federal government. But the federal government created the status of a United States citizen and forced it onto the states. It is the creator of that status. Everyone in this room, with the exception of a few, has sworn an allegiance to be a United States citizen residing in a state. You have not sworn to be a state citizen. Now, a lot of people get very confused with the wording of the 14th Amendment, which says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside, and they take great comfort in and in the state where they reside. But again, what state do they reside in? They reside in a state composed of United States citizens. They do not reside in a state composed of state citizens. That status was eradicated by the federal government. In getting also to the erosion of our religious foundation, the federal government during Reconstruction annulled the in North Carolina, you had to have a belief in the Old and New Testament in order to hold office. They just changed it to you had to have a belief in a God, which is where we are today.
I'm going to give Ms. Publius the final word on this and move to the next question.
I do not understand my colleagues' comments, but I assure you that it is the enumerated powers which define the limits of the lawful authority of the three branches of the federal government. The 14th Amendment did nothing to expand the jurisdiction of the federal government over anything except freed slaves and to protect them from the Southern Black Codes, which denied them basic God-given rights. The 14th Amendment did not constitute a blanket grant of power to the federal government to do anything that they felt like doing. You must bear in mind the list of enumerated powers.
Okay, we're going to give KrisAnne the last word on it and we'll move to the next question.
I just got beat up.
Okay, so here's the real issue. Remember, the Constitution is a contract where the states are the party to the contract and the federal government is the product of the contract. Okay? The product of the contract cannot renegotiate the terms of the contract.
Right.
And so any renegotiation of those terms is an illegal act on its face, which means the negotiated contract by the federal government is an illegal document which reverts to the original contract as the legally binding document. And it's what I said before, it's the difference between legal authority and assumed authority. The product of the contract cannot renegotiate the contract and make a new contract. It's not possible. It's not legally possible. But we assume that they have the authority to do, so we act under that. The legal response to that is to simply deny them that assumed authority and return by practice to the original and only legally binding contract.
I'm in total agreement. This I think is the crux of everything here. I think it needs to be dealt with.
30 seconds.
Well, I mean,
The next question goes right into this.
go ahead.
All right. How do we, or can we, nullify the Reconstruction Acts, which were unconstitutional on their face, or as you said earlier, an act that was basically passed through coercion?
That's exactly where I was going. Thank you, David, for that.
Well, that's why.
Let me jump in first real quick and then you can finish up. I will tell you we don't need to nullify the Reconstruction Acts because they're already null and void because they originate from an illegal act. Nullification is not an act. Okay, it's not simply a power at all. It's the recognition that something is illegally stated and illegally established. It's not something that we have to do, it's something that we have to recognize already happened. You don't have to nullify my action, my ownership of your car if I've stolen it, because the original act itself was illegal, making my ownership itself illegal. You don't have to nullify the Reconstruction Acts because they don't legally exist. They have no legal power over you.
Thank you for articulating my position 100% accurately, because we are nullifiers. What did the Reconstruction Acts do? If they're recognized, they created a new body politic. They created a new status of United States citizenship, which, as Elk versus Wilkins said, gives Congress exclusive, it gives them not merely subject in some respect or degree to the jurisdiction of the United States, which is Congress, but completely subject. That is an extension of a fraudulent extension of power. I agree that it's all fraudulent. But the nullification process is, what did the Reconstruction Acts do? It laid aside the original North Carolina Constitution. It said it's a dead instrument. Yes, it did.
It may have said that, but it did not do that. The Reconstruction Acts do not have the authority
I agree.
to take over the North Carolina Constitution. It doesn't happen. So to say that the Reconstruction Act set aside the North Carolina Constitution is completely false, because it did not happen that way. They don't have the authority to do that, so what they did not do that. Period.
Do you understand what actually happened in Reconstruction?
Say that again? They're what?
U.S. citizen.
No, I think
No,
they're still driving the car.
Let me
Right.
say
It's
this.
the matter
wait,
of assumed
wait,
authority
stop,
and legal authority.
stop.
I've got a question.
No, hold on. We're going to go in order here. It's now Ms.
Okay.
Publius' turn, and then we'll go back.
What's the question?
The question. Do you want me to repeat the question?
Yeah.
Okay. The question is, were the Reconstruction Acts and was the 14th Amendment legally ratified, since it was based on coercion in order to rejoin the Union?
So the question is, was the 14th Amendment legally ratified?
Right.
Is that the question? Okay, look, at any given point in time, we are where we are. People say the 14th Amendment was not legally ratified. The 16th Amendment was not legally ratified. So some people say it wasn't legally ratified, some people say it is. But the fact is, those two amendments are on the books as being part of the U.S. Constitution, and they have been recognized as such for a number of years. The solution, the easiest and the most logical and the most rational solution, is to get an amendment repealing the 14th Amendment and the 16th Amendment. That way, you don't have people squabbling from now until the end of time as to whether those two amendments were legally ratified or not. Just repeal them with a new amendment which repeals them. And it's done with, the issue's closed, and the Patriots can move on to something else.
The other thing we need to recognize about the 14th Amendment is it's completely superfluous. In its ratification or not ratification, in its text, is completely superfluous. It did nothing, okay? It's based on the lies built on the premise of the war between the states, that it was all about slavery. We don't know our history, okay? Number one, the 15th Amendment did not give black people the right to vote, and neither did the 19th Amendment give the women the right to vote. Okay, you'll notice that neither one of those amendments say we give that right. It says we recognize the right already exists and it can't be taken away. Because the true history of that is women and black men voted long before the 14th and the 15th and 19th Amendments. It was based on ownership of property, and the fact that we ratified amendments in the 15th and 19th Amendments to the Constitution was completely unconstitutionally sound anyway, because voting is not a federal issue, it is a state issue. Now, the 14th Amendment tries to say that we created citizenship for the slaves, which is completely ridiculous. Freed men before the 14th Amendment became citizens of the United States. Freed men before the 14th Amendment, before the Civil War, became citizens of their states as soon as they became freemen, and their children became freemen. See, we just don't know our history. The first lawsuit against a slave owner in our states was a lawsuit against a black slave owner who refused to free allow his black slaves to purchase their freedom. It was a mechanism, just like all these other redundancies that we are now creating in our Constitution and by law because we're too ignorant to know what it really is supposed to mean. And when we spend all our time focusing on these issues, that it's like choking on the gnat while you're staring at or choking on the camel while you're staring at the gnat. We have huge problems in this country with an out-of-control federal government. Squabbling over what citizenship we have is not going to fix this problem. If we want to fix this problem, we need to look at the solutions. You want people to recognize that they are citizens of a state and not citizens of a federal government? Then start teaching state sovereignty. Start teaching the foundation of the original document, and stop spending all our time on these issues that are just simply distracting and confusing. And I don't mean that in an insulting way. I mean, this is your passion, so you teach this, but you have to recognize that we must return to fundamental building blocks. You want to argue that the original Constitution was overturned and we are now into this false Constitution that turns over everything. Well, that sounds great, unless you recognize that only 3% of your audience even knows what the original Constitution meant and really did.
John, I'll let you wrap this one up.
I totally disagree. I totally agree with some aspects and totally disagree with others. I find it strange that we have individuals that speak of nullification being an issue, and the issue is that the concept that was expressed here that the Reconstruction did not create a new state or a new constitution is totally false. I mean, if you know your history, you have 1868 Constitution, had a totally different body politic. You know, anyone that listened to the presentation saw that, and to say that it did not do that is we're not knowledgeable of our history in that position. The Reconstruction Acts are very clear that they annulled the states, whereas no legal state governments now exist. They're very clear that they changed the body politic. The Reconstruction Acts had 3 supplemental acts which further defined who is disfranchised and who is the body politic. When you get to Article or Section 5 of the first Reconstruction Acts, and look at this. Listen to these words and see if this is the amending process of how we pass amendments to the Constitution. And I read it earlier. It says, and be it further enacted that when the people of any one of said rebel states shall have formed a constitution, and again, that's a different constitution, composed of not the freemen of North Carolina, Constitution and government in conformity with the Constitution of the United States in all respects, and when said state by a vote of its legislature elected under said Constitution shall have adopted the amendment to the Constitution of the United States proposed by the 39th Congress and known as Article 14, and when such article shall have become part of the Constitution of the United States, the state shall be declared entitled to representation.
We're not going to do that.
Is it in Article 5 of the Constitution of how to amend it this prescribed manner? Our position is the state that was created, and again, you got to just go to the facts. You just got to go to what's actually written on the paper. This is what's written on the paper of the Constitution of North Carolina of 1868. Who can vote? Who's the body politic? Every person born in the United States, age 21. The original Constitution was for every freeman of North Carolina. Are those the exact same body of politics? The answer is no. So to sit here and say it did nothing, and to sit there and say that this is frivolous, this is the foundation.
Okay, I didn't say it was frivolous.
We're gonna
Choking on gnats and all that, I think, was indicating it was frivolous.
No, it's just a
distraction.
distraction
Yeah.
from a bigger picture
Yeah.
and a more powerful solution.
No,
Yeah.
I disagree, because we are exercising nullification. Both of you say that you promote nullification. You say the Reconstruction Acts did nothing. We have a right. They changed nothing. They changed the Constitution. They
can't
put aside
change the, did
Okay.
they change the North Carolina Constitution or the federal Constitution?
both.
Okay, because they don't have
No.
the power to do that.
No,
I know.
They
That's
did.
what we say.
So
they
stop
did not.
saying they changed it because
they
it
did
didn't.
not change
In
the federal.
application, it changed.
No, it didn't.
All right, hold on.
Has anybody read any court ruling that talks about it's based upon the
You know
validity of the 14th
What
Amendment?
exactly does the
We're gonna cut
what
this
exactly
out. We're gonna
does the
cut it
Supreme Court have the authority over to describing the federal power? He keeps returning to the authority of the Supreme Court, but then wants to not recognize the authority of the Supreme Court. You can't use the authority of the Supreme Court to establish your argument that something happens when you already say the Supreme Court has no authority over that.
Okay, I agree. The issue is, what has the Supreme Court ruled? The
The court
meaning
doesn't make
of
rulings.
Opinions.
They issue
what is the
opinions.
opinion of the Supreme Court in Elk versus Wilkin on the powers of a United States citizen concerning federal authority?
It is irrelevant what their opinion is.
But
because
this
it
is how they
contradicts-
operate.
Yeah, but that's the point. You have
And-
to teach people first the building blocks. Because here's the problem. I'm not describing the validity of your concern. I'm saying we've got to build the building blocks first. This is why these kind of concepts make people look at other people and think, well, this is crazy, this is conspiracy, this is all tinfoil. It's because it's beyond their comprehension, okay? The average person, I am not saying it's conspiracy, I'm saying the average person looks at it because they do not understand the building blocks. You want them to return to an original constitution, you tell them that it was all usurped, but it wasn't usurped because it wasn't legally usurped, but they have no understanding on what the original document was to begin with. We've got to return to the basics before. You do not teach your child calculus before they understand ABC 1, 2, 3.
All right, we're gonna wrap this one up. We're gonna wrap this one up.
The original
We're gonna-
Constitution was vacated.
No,
Because
it
I-
wasn't.
It can't be vacated.
Look, you're
Can I-
going to lose the audience. We're going.
Yeah,
I know
right.
what you're saying. We're going to lose the audience.
Supreme law.
It's
All right,
we agree.
It's
We're the ones saying exercise it.
Right.
All right.
Quit
Exactly.
obeying the usurpation.
next question to KrisAnne. In your talk, you said that the Constitution is a compact.
Mm-hmm.
I think you did a good job overscoring that. At what point is that compact voided by the federal government not using all of it? And I'll give you an example. I'll give you several examples if you'd like. But at what point is that contract completely nullified when a portion of it is not adhered to anymore?
Well, that's a really good question, but I would tell you that would be the answer to that question ultimately is something that rests within the individual states. Contracts can operate with severability. So if the operator of the contract can continue operating that way just to correct the error. Now, here's the real problem. The states are the parties to the contract. The federal government is the product of the contract, okay? So when the federal government operates out of its prescribed limits according to its defining and creation document of the Constitution, it is up to the states to get its creation under control.
Right.
Here's the key. When the federal government operates outside of its constitutional limitations, and the states do not check it, it is the states who are breaking the contract, not the federal government. The federal government cannot break the contract because they are a product. The parties are the ones that are required to keep the contract in its functional integrity. And so the real breaking of the contract is being operated by the states of the Union, who are refusing to keep their agreement with the other states to maintain the limitation of their creation. I can't remember exactly where James Madison says this, but I have it in a slide in one of my things. He says that the usurpation of state power against one state would not excite just one state or a few states, but all of the states would then work together in concert to overturn the federal usurpation, because they knew if the federal government would usurp the power of one state, then they would work like a steam engine and roll over all the others. So he said one state would ignite the other, and we would begin to move in accord. That's the whole purpose of the Union, to work together for our general welfare, for our common defense, so the states work together for their prosperity. And then he said, the states would all come to each other's defense to keep their creation under control. And then he said, but what degree of madness would ever drive the federal government to such an extremity? And Madison simply describing our federal government in a state of madness. Why? Not because the federal government is out of control. We expected this from the federal government. Every single government on the planet wants to be a kingdom. Every one of them. It's a natural human nature thing. And so some want to be a kingdom because they have their good intentions and they think they can do good things for good people. Some want to be kingdom because they're evil and they want to exercise unlimited power over others. But they all want to be kingdoms. And the purpose of the constitutional republic, as opposed to a monarchy or an oligarchy or some other form of government, was so that the states would be the governors over their creation. So if you want to get really technical in the matter, it's the states that are violating the compact by not keeping their creation under control.
Ms. Publius?
KrisAnne has most eloquently paraphrased what James Madison said in Federalist Paper number 46.
Yay! Thank you. So now you have the reference. You can go read it.
John?
What was the question?
If the federal government is not adhering to the compact, is it still valid?
Well, the original North Carolina Constitution, the very first sentence says, whereas allegiance and protection are in their nature reciprocal, the one of right should be refused when the other is withdrawn. In a contract, when one side violates it, and this was our principle upon which we left we did the Declaration of Independence and left the Crown. Let me restate that. Whereas allegiance and protection are in their nature reciprocal, you give allegiance to the state, they protect your rights. One of right should be refused when the other is withdrawn. When the state refuses to protect your rights, you have no legal obligation to it, and that's the foundation of the Declaration of Independence. It's basically the Declaration of Independence was an indictment. It was a declaration of indictment of the crimes of the Crown and the list of usurpations and further crimes, and resulting in, therefore, we are in a right ought to be a freedom and a people because they had withdrawn their protection. That's the legal remedy that was used in the Declaration. The situation we have today, it's very clear that there's a lot of confusion here. The federal government violated the compact with the American Civil War. It waged war on states. Article 3, Section 3 says treason consists in levying war on states. I need y'all to be quiet for a second. They annulled the states. They created new states. They took the original constitutions and they used the military and said you cannot repopulate them. I know the state of North Carolina proposed a constitution in 1866 to try to come back into the Union. The federal government denied it. They said, no, you got to do the one through Reconstruction. And we're changing who can vote. And it's going to be only United States citizens. That compact is not the original compact. You do not have, this is where nullification comes in, you do not have an obligation to a government that is here to subjugate you. And that's what they're doing. They're at war. We are at war with them. They are here to make us subject. Elk versus Wilkins was very clear on that. Make us subjects. And the remedy lies in taking those documents, taking the North Carolina Constitution that was originally put in place by the consent of the people of North Carolina, that was an original, was the original government of the body politic that was a member party to the Constitution, that created the Constitution, and repopulating it, and filling those offices, and reestablishing it, and nullifying the Constitution and state body politic they put into place. This is nullification at its hardcore, and this is the foundational issue. This is the foundation. It appears that everyone here wants to ignore that foundation of Reconstruction and pretend these powers that they're exercising. If you look at every landmark Supreme Court case, Roe versus Wade, Murray versus Curlett, Madeline Murray O'Hare, Stone versus Graham, taking away the display of Ten Commandments, Lawrence versus Texas, taking away the criminality of sodomy. All of those are based upon the federal authorities, the federal courts operating off the principle that the 14th Amendment gives them the authority, because that's what they say is violated. The 14th Amendment was violated in every one of those cases.
All right, we're going to give Publius the last word on this and then move to the next question.
Okay, the 14th Amendment did not delegate to the federal government power over abortion, homosexuality, marriage, and the like. The Supreme Court usurped power over those objects. In the pardon?
Opinion.
Yeah, the Supreme Court usurped power over those objects when they issued their opinions in Roe v. Wade, Lawrence v. Texas, and in the marriage cases. The 14th Amendment did not legalize federal increases in power over those objects.
Well, let me.
It's important that you understand that.
Well, let's move to the next question, which actually goes on to this. I'm sure you're familiar with the latest Supreme Court ruling.
Opinion.
No, opinion.
Okay.
No,
Well, they are rulings.
No, they're not.
no.
Okay.
The
Okay,
document even
opinion,
says
yeah.
opinion. It doesn't say ruling.
Kings
Yeah.
do rulings.
That was my point I was going to make.
Yeah.
Here's the question. In a Supreme Court opinion, where they said the intent of the Affordable Health Care Act was this, and not what the law stated. Judicial activism at its best. What is your thoughts on that?
Well, of course, Obamacare is totally unconstitutional because the medical care of the people is not on the list of enumerated powers. Everybody understand that? Okay, so the Obamacare was unconstitutional. It was the duty of the judges on the U.S. Supreme Court to obey their oath of office, which is set forth in Article 6, Clause 3, which is to obey, to support the Constitution. So it was the duty of the U.S. Supreme Court to declare Obamacare unconstitutional. Instead, the U.S. Supreme Court did something which James Madison and Alexander Hamilton warned us about in the Federalist Papers. They connived with Congress to usurp power over the over the American people.
One thing that we need to remember again is that what Patrick Henry said, I have the one lamp by which my feet are guided, and that's the lamp of experience. I know no way to judge the future but by the past. We are not in a brave new world. We are not experiencing anything brand new. We are not a new territory, okay? We are just simply repeating the same ignorant mistakes that we've been repeating for 1,000 years. And let me explain to you where this comes from. Our Constitution is the creation of is the result of 5 documents written over 700 years. These 5 documents comprised the British Constitution. Our Constitution is an evolution of British law, and it is a continuation of the British Constitution. Alexander Hamilton explains that in Federalist Papers 84. and that it's an advancement in that we said no to kings and said yes to constitutional republics. Now, in those 5 documents that make every aspect of our Declaration, our Constitution, and our Bill of Rights, our Declaration of Independence is not even an original document. Our Declaration of Independence is the exercise of Clause 61 in the Magna Carta and a repeat of the Petition of Right of 1628, the Grand Remonstrance of 1641, and the English Bill of Rights of 1689. Every aspect of our Declaration of Independence can be rooted back to the grievances listed in those 3 documents. Jefferson didn't write it. He just simply rewrote in his modern terms those grievances against their king. And in 1641, the Grand Remonstrance starts off in its preamble and says, "The root of all this mischief we find to be a malignant and pernicious design, subverting the fundamental laws and liberties of our kingdom." Now, if we sort of translate that into modern terms, they're basically saying we've been watching tyrannical government for 600 years and we're noticing a pattern. The same bag of tricks over and over again. And then they identify the pattern. The first step, always, throughout history. And we do ourselves a great disservice, by the way, by saying that we went to war with Great Britain, our own country, over taxes. The Boston Tea Party was not about taxes, by the way. That is a ridiculous assertion, denied by every aspect of history. And I just read the other day somebody saying that the Magna Carta was the result of a war over taxes, which is also really ridiculous. But nonetheless, when you read the Grand Remonstrance of 1641, you read those grievances, you see this mechanism of tyrannical government. And the first step is always corruption of the court systems. Always. Then they said, through the corruption of court systems, you will always get an infiltration of foreign law. And then you will have the government in one order or the other, diminishing the property rights of the people. You will have the government getting involved in the church, stealing the authority of the church and turning the church into an arm of the government. He said you will see fiat money created so that the government can manipulate the monetary system and manipulate the people. And then you will finally see the government disarming the people while the government remained armed. Now, we didn't have the opportunity for me to teach this full 700 years of history of our Constitution to us. But when you learn that history, it becomes indisputable that our framers knew their history.
Educator.
And they did everything that they could to keep us from preventing those mistakes. Those who do not know their history are doomed to repeat the mistakes. And so what we need to understand here is that we were established with a mechanism based on the Constitutional Republic where the states held all the power over their creation. The creation has no power over the creator other than what is delegated. We act like power was surrendered. It was not surrendered, it was delegated. And it's the obligation of the states to take that back under their control.
John?
What was the question again?
Well, actually, let's go to the next question. It's yours. Everybody here has talked about nullification, the 9th and 10th Amendment, and what, in a perfect world, it should be. But the reality, at least in my mind, is in North Carolina legislature has been bought and sold by the federal government. They want the grants. They say nullification is illegal. They ignore all the evidence to the contrary, and you can't even bring it up in the legislature. So my question is, if the states have given up, why should we rely on the states?
I think you need to rephrase that. If your state has given up, our state has not. One of the things you got to do is, the Lord tells us, you don't judge someone by what they say. You have to judge a tree by the fruit it bears. You have to judge by actions. And with the Reconstruction and things of this nature, you got to judge by what the court opinions are saying. And to say the 14th Amendment, because it was unconstitutional, has no force in law and doesn't have any binding, when you read every one of those opinions, they get the authority to rule on homosexuality, abortion, prayer in school, based upon what they say is their power they got from the 14th Amendment. We listened to James G. Blaine earlier talking about the object of the 14th Amendment was to rid this nation of that pestilent heresy called state rights. How does the 14th Amendment rid this nation of state rights? It rids this nation of states' rights by getting rid of state citizenship. I'm going to go back. I'm going to say this, and you can go back and look at every one of your voter registration applications in Texas, Tennessee, Virginia, North Carolina. In order to vote, you're required to be a United States citizen residing in that state. You are not required to be a state citizen. Now, going back to this as far as nullification of the state of North Carolina in operation today is the created. It was created by the federal government. The federal government said it could not secede, made them put it in the law, said they could not nullify it. Okay? It would be revolution for them, since they are the created, to try to do that. Who has the right to nullification? People whose oath and allegiance is to original states. That's us. And we are exercising that right of nullification. I just find it very strange that we have people espousing exercising nullification, but when we have a real life example here, it's no, that's the wrong way.
I'll let KrisAnne go next.
You know, I'm really sort of the circular logic that keeps going on in this conversation is really sort of distracting, so I'm not quite sure how to address that. Nullification is absolutely what we should be doing. The idea that we can't because the creation forced us into a new contract is circular logic. And so it is self-defeating. So I think we need to sort of set that aside at the moment and get really onto the issue here, because the question is this. If your state refuses to engage in nullification, what are the options?
Exactly.
Right? That's the issue, because we're talking about solutions here. And that's where we need to be focused. And the solution is not pointing fingers and laying blame. Oh, you did this and they did this, and we've somehow given an authority to a body that doesn't have the authority, so we must submit to that authority kind of thing. The real solution is this. If your state, and this is why the Constitutional Republic was established the way it was, because our framers knew that government governs best when it governs least and governs at home. They knew from their history that we would never have control over the federal government in the way and in the magnitude that we would over state and local. That's why all the power was resting in the states. And so nullification works through the body of the people. And if your state legislators will not engage in their proper nullification, and I'll tell you, because this is how we're doing it, all over the country. The states who will not comply and engage in nullification, the people are then doing that on the county and municipal levels. This nullification is not an action. It's a recognition that the federal government is acting outside the law, and every action they take, whether it be by Supreme Court opinion or federal law, is not legally binding because its first act is illegal. In the law, we call it fruit of the poisonous tree. You cannot create a power from an illegal source. And so, for example, Grant County, Oregon, has passed an ordinance in Grant County, Oregon that says the Forestry Service has no power to shut down their roads. And what you have to understand about the topography of Grant County, Oregon, they are a forest, okay? And so what they said was that if the federal government tries to shut down our roads, we have the authority to take down those roadblocks and arrest anyone who tries to reestablish them. Kansas did that on the state level with gun laws. In Florida, we have a municipality who passed a law, Second Amendment Preservation Act, said no city funds will be used in the enforcement of any federal gun laws, and anybody who uses city funds to enforce a federal gun law will be charged with a crime and will be prosecuted to the fullest extent of the law. And so what we have to understand is, as Ms. Publius said, nullification comes from a natural right. The first law of nature is self-preservation. And in that law of preservation, Samuel Adams wrote a document called The Rights of the Colonists in 1772. He said, among the natural rights of the colonists are these: first, life; secondly, liberty; third, property, together with the right to defend them and protect them in the best means possible. Nullification is the exercise of that final self-preservation and self-defense. And so if your state won't do it, then get your county to do it. Because if you don't have control over your county commissioner, that's your fault. Because your county commissioner is your next door neighbor, and you can camp out on his stinking front lawn if you need to. If you don't have control over your city councilman, that's your fault. And you can control from the inside out, and that's how it's supposed to work.
All right, I'm going to let Ms. Publius do the last word on this, but before I do that, in this state, if the county commissioners go against what the state legislature says, they have the legal authority to remove the county commissioner and insert a new county commissioner.
I have forgotten what the question was.
Okay, the original question was the 9th and 10th Amendment. If the states do not follow that, they basically have already given up, and they have ceded power to the federal government in exchange for the federal grants and their own power. What is our recourse?
Okay, so the question is, what should the people do when their state legislators are too cowardly to nullify, to refuse to submit to unconstitutional acts of the federal government?
Exactly.
Is that the question? Okay, well, the first thing you need to do is, many state legislators are totally clueless about the legality of nullification. They are totally unaware that James Madison was a staunch supporter of nullification. Randy Barnett, a law professor at Georgetown University, has put out the lie that James Madison opposed nullification.
That's a fun one, isn't it?
Robert A. Levy, I think it is, a lawyer with the Cato Institute, has repeated
Bob
this.
Levy. His name's Bob Levy. I actually debated him on the issue. He's a federal supremacist, yeah.
Oh, okay, Levy.
Yeah, Bob
Okay.
Levy.
Yeah, Levy, right? Okay, he's a lawyer with the Cato Institute. I bet you thought the Cato Institute was your friends. By the way, they have received, according to what I saw on the internet, funding from George Soros. Anyway, Levy has repeated the fabrication of Randy Barnett, law professor, that James Madison opposed nullification. So there's an awful lot of misinformation being put out in the public square by people who pretend to be our friends. I believe that Mark Levin also repeats the fabrication that our friends opposed nullification. So we the people read the paper I wrote, arm yourself with the hyperlinks and the actual quotes, and start shouting the truth about nullification from the treetops, from the every chance you get. And then of course KrisAnne is absolutely correct. If your state legislators still don't do it, get your local elected bodies to nullify unconstitutional acts of your state and federal government. And remember Rosa Parks and Martin Luther King. And remember the brave citizens in Connecticut. Brave citizens can nullify unconstitutional acts of the federal and state governments by saying, "No, I will not comply."
Hear, hear. We're going to move on.
Okay.
All right. Next question is for KrisAnne. We talked a lot today about the creature. It seems like the creature is feeding upon itself at this point. And I'll give you a good example. The Iranian Accord. We have the Constitution spells out implicitly what and how a treaty is enacted and approved. Renaming it to be an accord and completely changing that is what has happened. So I'll let you comment on that.
Well, the first step to everything is education. You have to teach people where we are supposed to be operating so we know where we're supposed to go. We have no litmus test, right? We have, how many of you realize we don't teach the Constitution in law schools anymore? We teach constitutional law, which teaches our judges and lawyers that they know more about the Constitution than the men who wrote it, and that then we spend the rest of the time teaching our lawyers how to circumvent the Constitution to get to win their argument, which is why our courts are in the situation that they're in, and they have absolutely no credibility whatsoever unless we give them credibility. And so what we need to really understand here is this. The Constitution, again, deliberately enumerates specific powers. Now, it is really hard to discuss these things without getting into a little bit of the education. But James Madison and the Anti-Federalist Cato and Alexander Hamilton had a huge discussion over the proper placement of power with the president. Okay, they were really, really concerned about creating a president that will operate like a king. In our constitutional debates, we considered having a tribunal as the executive branch. We considered having a parliament or one person. Through a series of reasonings, they determined that a single president would be better for the purpose of negotiations and trades and that sort of thing. Now, in this conversation that the Anti-Federalist Cato and James Madison and Alexander Hamilton had over this understanding of what power the president should have so he doesn't become king is where we need to really understand why treaties are limited the way they are. Remember, when you have a question about what to do, the very first question you must ask to answer that question is why? Why was it established this way? What was the purpose in limiting in this manner? And the single purpose for limiting the treaty process in this manner was to keep the president from acting unilaterally as a king. And so the treaty process was that the president can negotiate a treaty in his foreign affairs duty, but the treaty is only binding on the citizens in the states if it is ratified by 2/3 of the states. Because here's the deal.
Senators.
Or the senators. Yeah. Well, but that's what I mean by states.
Yeah.
Okay? And that's a little Freudian slip for me because the Senate is supposed to be the representatives of the states. Yeah. They are the voice in federal government on and behalf of the states, which is why treaties could only be ratified by 2/3 of the senates. And so the reason was kings could make treaties without anybody's approval. And they didn't want a king. Kings had the unilateral power to declare war, to conclude peace, to make alliances and engage in foreign commerce without any governing body at all. And they said, no, we're not going to have a king. So the only way we can have a treaty that will reserve the power to the states and protect the liberty of the people is so that the president can make the treaty, but it is only legally binding with 2/3 of the Senate. So the Iran deal is not a treaty. It is an international executive order, which is not legally binding on any person in this country or any state any more than a national executive order is binding upon us. They have no legal authority.
Right.
We just simply have to then educate people why the president shouldn't have this power, and the reason why we are not legally bound by it. We shouldn't even recognize its existence. And here's what should happen. The governors of each and every state should step up and say, our representatives in the Senate did not ratify this. And since they did not ratify this, we are not legally bound by it. So any trade agreement that you make is not binding on us. We will not participate in it, we will not honor it, and we will not uphold it. And that's the solution. So now we know why it's there, what it means, and the solution to making it right.
John?
I'll pass on that one.
Ms. Publius?
I applaud KrisAnne for her brilliant answer.
All right. We're at
I'm humbled, thank you.
2 hours in. Do you want to continue one more question or do we?
Well, one more question. I have an hour and a half to drive back,
Yeah.
so
Yeah, and
Just have
we
mercy
got
on me.
Well,
we
we
got
can-
to drive.
We can do one more question or we can give everybody like a 3-minute wrap up. Up to you.
oh, I don't need 3 minutes, but that's okay. Yeah.
Yeah.
Wrap up, be fun.
All right. We'll go backwards since we start with you. We'll start. You can start right now.
Okay. The best thing that I can tell you is this. Samuel Adams said, "No people will tamely surrender their liberties, nor easily be subdued when knowledge is diffused and virtue is preserved. But to the contrary, when we become universally ignorant and debauched in our manners, we will sink underneath our own weight without the aid of foreign invaders." Every single question here illustrates a desire to seek the truth and a desire to seek the information and the wisdom and the knowledge. And I applaud that. That is really, really awesome. These are the questions that we need to be asking. But the fact that we are asking these questions and the fact that the federal government is operating in the manner that it is proves to us that we have reached that place of universal ignorance. And so the only way we are going to fix this in any way, shape, or form, whether it be on the individual level between friends or on the local government level and on the state level, is to start engaging in the right questions so we get to the right education that makes the right answers. The key to learning is asking the right questions. Why? How? And once we ask the right questions, then we know how to search for the right answers. I have an ability to connect dots. And you know, some people can sing, some people can play music, some people can dance. I can't dance. Don't ask me to. It's ugly. But I can connect dots. And I want nothing more than to teach you how to do that. And so what we want to do here is give you the tools that you need to start asking the right questions with the right people so that we can start heading back in the right direction. And so I want to thank you for the opportunity to be just a humble voice in the crowd teaching some truth.
It's very good. You speak very eloquently. I agree with everything you say on the intention of our founding fathers and what the Constitution was about, with both of my esteemed panelists here.
Esteemed.
The issue that I think at hand is, and the issue to remedy of what the problem is every individual must decide what your legal status is, who you are. And you do that by swearing oaths. That's what wars are about. You got to swear an oath to the new kid with the most power. If anyone here is voting, now we got this concept out here that the Reconstruction Acts are a nullity. They have no force. They didn't do anything. They didn't change any of the constitutions. Nothing happened. When you fill out a voter registration application, you have to swear under penalty of perjury, class 1 felony, that you are a United States citizen. A status that supposedly doesn't exist. It's absurdity to swear an oath to something that you say doesn't exist. We talk about state citizenship. You have something called the center of gravity doctrine. The center of gravity doctrine is, people say they're one thing, but you got to go by their documents to find out who they actually are. Center of gravity doctrine comes into play most of the time during war. Used a lot during World War II. German citizens, or German heritage people over here who said they were U.S. citizens, but they were also voting in Germany. Center of gravity doctrine comes in. You say you're this. Who are you actually? When we swear an oath to be a status of something that doesn't exist, but we're claiming to be a state citizen of a state that's never been interrupted, there's no logical sense in it. The remedy goes to swearing an oath to a lawful state to be a state citizen, not swearing an oath, because that's all done voluntarily. It's all done voluntarily. You are individually, of your own accord, with no coercive measures, swearing that you're a United States citizen, and which is the acceptance of Reconstruction, 14th Amendment. I say swearing oath to the lawful states. Nullify Reconstruction. Nullify those states that are in operation that have no lawful authority. Quit participating. A vote in an unconstitutional state is a vote for an unconstitutional state.
Publius?
We're down to one mic.
My undergraduate degree is in philosophy, and I specialized in political philosophy, and I had to read Kant and Hegel and Fichte and Schopenhauer and et cetera, all kinds of philosophers. And I had to know the material. So what I learned how to do was to make charts. I would make charts of their entire philosophical system on huge pieces of computer paper so that I could lay down their positions on politics, ethics, epistemology, logic. I could lay out their entire system on one sheet of paper, then I photographed the sheet of paper in my mind, and then it was set. You can do the same thing with the Constitution, although it's much easier. Go through the Constitution, article by article, there are 7 articles, and make little charts. What does Article 1 say and do? What does Article 2 do? What does Article 3 do? What does Article 4 do? Article 5, Article 6, Article 7. Make charts. Do the same thing for the Declaration of Independence. In the process of making these charts, you will learn these 2 miraculous documents. Get study groups. Tell your friends, your children, your grandchildren. This is really 12th grade material. The only thing in this Constitution which everybody cannot fully understand is the jurisdiction of the federal courts set forth at Article 3, Section... My goodness, I'm tired.
6.
Article 3, Section 2, Clause 1, which sets forth the enumerated powers of the federal courts. You really need to have a background in litigation to understand that fully. But any layman can read that clause and understand that the jurisdiction of the federal courts is limited to only a handful of cases. So learn these 2 documents and grill your candidates for office. These worthless people we've been electing to office, they don't have a clue what these documents say. Expose these candidates as ignoramuses. And learn this yourself. It's easy stuff.
I want to thank the panelists and thank the audience for their time. Take a 5-minute break and we're going to start the raffle.